Hello, fellow toolboxers. Welcome to episode number 386 or 68. I think I got the numbers mixed up. 68 of the Immigration Lawyers Toolbox podcast. We're doing an interview with Kevin Gregg, our monthly, going over the, what is it called, federal court decisions from the month of February. Some interesting stuff. Definitely worth listening to. Before we get started, some housekeeping. Our E2 seminar is coming up on March 20th. It's at this point, a monthly one we do, talking about each month is different, but it's like a change of status to E2, a concept processing. A lot of people want to learn about this. So we create a monthly session with a lot of repeat people coming, actually. It's really good. So if you want to get involved in that area, you have doing it. You just want to see how I did it, just get some extra data to help boost your case. We have samples. We go through a case. It's redacted, but it really goes through the big parts of it. We're also going to be starting doing the NIW, National Interest Waiver version of the seminar. For that, I need to keep working on redactions and making it a good course before I officially announce it. But if you're interested in this stuff, email me at info@immigrationlawyerstoolbox.com. I'll send you the registration page for the E2 and NIW. You'll get notified for when it happens. So first thing I want to let you know about that, our community page on circle.so. If you want to become a member and you're a lawyer, we just got 25 people in like 2 days registered. So it's growing. We added a part to the site where now that USCIS is doing in-person interviews again with USCIS, if you have clients in other jurisdictions you can't go to, we're creating a database, a list. You could easily see different lawyers in different places, so you could contact them and let them know. Also, in the comment portion of the tab, I'm adding, and hopefully everyone else will keep adding timelines they've seen for that specific field office. So you have some examples of how naturalization takes or how long the oath ceremonies have naturalization, that kind of stuff. But also we have these AI broken down and reviewed. We kind of clean it up, but AI generated AEO decisions. So reading them, so you have a quick go-to kind of cheat sheet to find the case that matches what you need, and so you could then use that. So it's all free. Our community page. If you're a lawyer, send me an email, info@immigrationlawyerstoolbox.com. I'll send you info on how to join on that. It's really good to do that. The new magazine episode, issue 8 is out. Issue 9 is going to be coming out in a week or two. So download that. Just you can read it online or download it. Go to iltbox.com or immigrationlawyerstoolbox.com. Click on the magazine tab. We have a lot of good articles there. I give you guidance from colleagues. That's going to help you a lot. So it's a really good thing to do. There's so much more to talk about. But in particular, I want to thank the sponsor of the issue of the magazine and the sponsor of this podcast right here. You all heard of Mitratech's INS Zoom. Mitratech is one of the leading vendors in the immigration space and these forms. And they have some new products coming out. It's very interesting. Are you tired of sinking your most valuable asset into tedious data entry? Then it's high time to streamline your immigration process with Mitratech INS Zoom, the leading immigration software management software trusted by top law firms and corporations worldwide. Mitratech's INS Zoom helps you manage cases, track deadlines, and automate workflows so you can focus on what matters most, your clients. But that's not all. Mitratech's INS Zoom just announced and launched GovNotice IDP, a revolutionary AI-powered tool which automatically extracts critical information from your government notices and receipts. No more manual data entry, no more errors, no more headaches. Instead of traditional and highly time-consuming manual entry, USCIS notice data on GovNotice IDP automates the entire process, ensuring a faster, more error-free experience. Legal teams can upload batches of receipts in bulk with automated classifications and case linking, reducing processing time significantly. It helps incredibly highly accuracy of hundreds of notices per day. It gives automated email notifications for internal and external stakeholders, and it currently supports USCIS receipt notices, premium processing, as well as other approval notices. With Government Notice IDP, you can process and manage your cases faster and more efficiently than ever before. Ready to elevate your immigration practice to the next level? Learn more at hrc.mitratech.com/toolbox. That's hrc.mitratech, mitratech.com/toolbox. So it's going to help you out a lot. Having said that, all the information provided here is not intended as individual legal guidance. Please consult with an attorney about your case, but you all know that already. Hey, Kevin, thanks for coming on the show again.
Hi, John. It's my pleasure to come on the show again every month.
Yeah, definitely. And I'm sure you, as well as all of our colleagues, are swamped crazy with cases and worried people and rumors and all this kind of stuff.
It's a wild time, and not just rumors. I mean, they're going all in for the U.S. government and immigration. They have appellate Judge Searcy, I think is how you say. I think it's her name. She's issuing the craziest memorandums out of EOIR that I've ever seen in my life. She's clearly got a lot of anger in her, and then they've fired a bunch of people from the Board of Immigration Appeals, making it smaller after having made it larger during the Trump years. So I imagine they'll make it larger again. So yeah, these are wild times, and it's hard to keep up. Iris sends out a little internal newsletter to the firm multiple times a week. He sent something out today. There have already been over 100 lawsuits against the Trump administration since inauguration, which is equates to about 3 a day.
Yeah.
So, I mean, I don't like the stress test on the federal judiciary, but we're in the thick of things, no doubt.
Yeah, I mean, there's the NTA memo that came out, the N400, the I-485, really minor changes, but new additions came out on the fly yesterday. So now I have to redo all these forms and again re-signed. And poor people who
That's
had
just me.
deadlines. Imagine that. It's just that's harsh. You got to give 2 days notice. I mean, what the
And
F?
they didn't even they changed like two things. Like it's just so unnecessarily
Yeah.
cruel to change a bunch of forms without even substance. Where's the urgency? Where's the rush? There's none. It's just to screw people.
Because if
It's
someone like ages out because of this, because they have to redo the forms and submit next one day over because of like without any notice, there's got to be a lawsuit saying that this is unfair due process of some sort.
absolutely. But do you know how much lawsuits cost? It's most people don't want to do that, and they're banking on that. And you don't have status during a lawsuit. It's a really cruel thing. It's a really cruel
Yeah, it's out
thing.
of control. Well, it's expected. I was just bracing for it. I'm like, you just got to roll with the punches and fight back on this kind of insanity. It's like, it's just cruel. There's no like, you're hitting people that are like going to get status or something like that. It just doesn't make any sense. But
Yeah, in any denying on a technicality, and creating
yeah,
technicalities to deny on it, it's the worst kind of lawyering.
yeah,
It's really terrible to do that.
definitely. So, how's the judiciary going? How's the federal courts doing in February?
Oh, I only picked the good ones for your show, and so I've got three good ones,
Okay.
and the good they were. Uh, Lapadat et al. V. Bondi out of the Ninth Circuit on February 12th, 2025. I went on and on about this case on my show, and no matter what circuit you're in, but certainly the Ninth Circuit, if you have a Roma case, also known as gypsies, not, I guess, derogatorily known as that, but it is the more common name. But if you have a Roma case, this is the case. This is a barn burner of a decision on asylum and the Romas in general. Essentially, these were Romanian Romas from Romania claiming asylum based on how Roma are treated in Romania, and the IJ and the BIA, in essence, denied by relying in large part on these things that the EU is trying to do to combat
Yeah,
historic Roma discrimination. But like as the Ninth Circuit points out, the EU is not a country.
yeah,
The Lepadats are not getting deported to the EU; they're getting deported to Romania, and so it's not overly important at all what the EU is doing. So that alone is an important holding, because you see that I've seen that in cases regarding an EU country, they try to point to EU policies, but that is not how asylum works. You focus on the country. And here, quote, discrimination continues to be widespread across the EU and is present in all societies and in all key areas, says the Ninth Circuit. Like many Romani people, they've been mistreated by the police and Romanian public for years because of their ethnicity. Like this is chock full of quotes about country conditions, factual quotes. I did a LinkedIn post about this actually yesterday, using case law to prove country conditions. What better way to do it? Be it for asylum, hardship waivers, cancellation, anything that requires you explain to the adjudicator what's going on in a country. I love relying on circuit decisions saying what's going on in a country, because how do you combat that?
yeah,
You really, it's very, very difficult. And the Ninth Circuit goes on and on and on. And so, of course, it was remanded for the Lapidats. But also, the Ninth Circuit says, look, not only that, not only did they suffer past persecution, for example, the male was shot in the back of the head, like the fact that the agency didn't find that to be past persecution is quite crazy. I'm not even going to get into what happened to the wife and the children, but so sent back for that. But also, the Ninth Circuit flat out says, quote, Roma are a disfavored group in Romania, end quote, which is a way to get asylum even if you don't have past persecution. Quote, today's rhetoric against the Roma is very similar to the one used by Nazis before the mass killings started in the 30s and 40s, end quote. My God, what a quote for your cases. For example, if you have Roma in any circuit. So Think about Lapidat et al. V. Bondi, February 12th, 2025.
I, I mean, if they're EU citizens, though, they can't just say, I'm going to move to Germany or something like that. It's just whatever country you have a passport from.
I don't think anybody's an EU citizen. I think you're a Romanian citizen and you have EU privileges. I'm not sure. I don't know how that's worked. I'll admit I've thought about that before as well. But I haven't ever thought deeply about it. I have a feeling that asylum law is not up to date with unique situations like that of the European Union.
Yeah.
It's still country focused, and there are very much still countries in the European Union.
Yeah, yeah. I think like you get EU because I have clients who get EU visas who say, "Oh, can I get US visa?" So I guess the EU as an entity can give visas for visiting, but the countries issue the passports. You have a German, you're still a national of one country. Yeah, although you have flexibility to move and get out of it, it's still less big country. If the laws are written based on country, you're right. You got to move based on what the statute is.
Right, I'm quite certain that the Lapidats are not citizens of Germany; that they're only citizens of Romania, for example.
Yeah, it's
And
just
citizenship and nationality are the only things that matter for U.S. immigration law.
let's have stuff about with regard to the Nazis. They are also exterminating the Roma people as well. That was one of the disfavored groups that was part of the mix with the Jews. So, uh,
Well, that quote said nothing about the Jews. I think that quote was actually about comparing what happened to the
oh,
Roma
I
in the
see. Yeah,
30s and 40s to what's happened to the Roma now. Absolutely.
interesting. Oh, that's interesting. Yeah.
Interesting case. Next, Funes Ortiz v. McHenry. There were a handful of McHenry cases before Pam Bondi became our Attorney General. This one's it's out of the Fourth Circuit on February 4th, 2025. I won't go on and on about it, but this is an interesting one. It's a Salvadoran, or no, it's not. It's a what country? It's a Honduran gang case. And amongst the many other things that happened to Mr. Funes Ortiz is a group of gang members who had been persecuting him showed up to his house, and one of them was in a police uniform. And the immigration judge, um, I believe the let me just make sure. I believe the immigration judge granted his case. Yes. Well, the immigration judge denied because I do believe he was a former gang member or gang affiliated or had some other issues. The immigration judge did grant cat protection to him, torture convention protection, but the BIA reversed that.
Wow.
And in doing so, one of the things they said was that guy who should there was no showing that the Honduran government would acquiesce or consent to the torture as is required of the Convention Against Torture. And the fact that that guy was in a police uniform that doesn't say much. That guy was just a gang member in a police uniform. The problem is the immigration judge kind of held otherwise. The immigration judge held either that guy had police connections because he said he did at the door, or he was police himself. Maybe that's wrong. Maybe it's not. But there was no the Board of Immigration Appeals is not allowed to just disagree
Yeah.
with an immigration judge on fact finding.
Usually it's the
It's
opposite
clear.
way around. Usually it's against the immigrant where the judge makes a finding. They say, "Well, we can't touch the facts," and they can't. We go.
Well, maybe that's true. Maybe it's not. But they are the more fun cases when this happens. And I talk about them on the podcast. The First Circuit actually has a great standard for this. That in order to overturn, this is out of the First Circuit. In order to overturn a immigration judge on clear error review, the IJ's finding must smell like a 5 week old dead fish. That's from the First Circuit. That's how bad it must reek. That's from the First Circuit. And so the Fourth Circuit isn't quite as colorful, but flat out, you can't reweigh evidence. Also, Oil tried to argue, well, the BIA was doing proper clear error review because as a government agency, they're entitled to a, quote, presumption of regularity, end quote, which, with everything happening at the federal government right now, is the height of chutzpah. But in any event, the Fourth Circuit's like, no, 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 that's not a way that you can get around our review. We're reviewing whether standards of review were properly applied. There is no presumption of regularity. The BIA either did the right thing or they didn't do the right thing. So, Funes Ortiz v. McHenry, that's a fun one. One of the few McHenry cases we had. Thought I'd mention it.
Very cool. Yeah, yeah. It's like you never. I'm shocked that the IJ was to the benefit of, and then they even pursued it and fought it out to want to appeal this case for on a cat case. Yeah.
It happens more often than you might think. I talk about them all the time on the podcast. Probably, maybe once every other month. There's
Mm.
a case like a remand where that happens. It does happen. Maybe it'll be happening less often as the immigration judge corps is purged. What with the fork in the road, probationary firings, and just general fear. I very much feel for my immigration judge and attorney advisor friends, and quite frankly, even people I don't know. I came from that agency, and this is not how it's supposed to work. No matter what side,
Yeah.
no matter what leaning you go on how immigration law is to be applied, this is not how we treat our federal employees. It's horrific. I'm offended. Um,
Yes. I
it's
mean,
not.
it was not
It's
only the
really
BIA,
horrible.
but some IJs got fired. I heard in Florida, like a good judge, we were saying they're sad that they're leaving. I don't know the judges at all. So, but
Yeah, a lot of no. The Judge Grimm in Orlando, two judges in Miami. The assistant chief immigration judge in San Diego got fired on Valentine's Day with the other 20.
oh no,
But
It was a Valentine's Day massacre. Literally, I was one.
Valentine's Day
Yeah.
massacre, and then a lot of the judges in San Diego too, and all over, they've taken with the fork in the road. They accepted Elon
Oh,
Musk's.
really?
That's what's happening, and it's just started coming to light last week. That's why there was this large exodus last week. For a variety of reasons, it really only came to light last week. So a lot of judges who've been there a while, especially, took the fork, as they're calling it. And a lot of them, a lot of these people are my mentors. I wouldn't call them necessarily like progressives. Some of them
Mhm.
maybe. A lot of them are just trying to apply the law fairly and trying to be human. And quite frankly, if you looked at their denials, probably would I don't know. Maybe the Trump administration would be happy with it. These weren't people trying to make a point. They were just people trying to apply the law, and that's what we should have as judges. This is a scary time. I'm going off on a tangent now, but I'm trying to also advocate for the federal employees every chance I get, not just in immigration. These are people who care about America and have been doing very important work, and to just arbitrarily fire thousands of them and upend their lives is insulting and horrifying.
I was talking with a colleague this morning, and he was saying like there's rumors that they might just get rid of EOIR and make it into like an inspector system. And I'm like, what is that? It's like before EOIR, there was inspectors, like a lawyer that you talk to, and like,
Right.
did you know anything about that?
I've heard I've heard of this rumor too. We'll see what happens. There are a couple of judges, at least one, although he took the fork in Miami, um, who started off as a special inquiry officer, is what they were called,
Yeah,
has now done like 4 decades as an immigration judge, and if he had just stayed on a couple years later, might have become a special inquiry officer
full
again.
circle.
Which
Yeah,
I mean, he was not a young man, but no, that I'm not even sure what they can do if they can do that.
yeah,
Or if I would imagine you have to change the regulations. That would be challenged. You can't just do that overnight. But scary times, very scary times. These are people's already the rub on immigration court is that there's not enough due process to be changing people's lives forever.
yeah.
To take away so much more is just wild to me.
Yeah, and one thing was they're just maybe terminating some cases who could get expedited removal and just doing that and not letting you get the full hearing.
Yeah, no, that's definitely happening. They're definitely going into court and trying to expedite removal. Absolutely.
All right.
You can only do so much.
Yeah.
Most people are not eligible for expedited removal, no matter how much the Trump administration tries to expand it.
Yeah.
So, but yeah, no, you can definitely pick up a bunch of these parolees. Absolutely,
Yeah.
they're targeting the biased parolees with that 100%.
All right. So I'll say the negative stuff. You get the good cases, the ups and downs. I'll pour in the rain in there in the middle of it.
Well, this is important to talk about because it's clearly a media onslaught trying to overwhelm immigration attorneys and just the American public in general. And so it's important to talk about these things and to explain what's actually happening. Some overreach and some not. Let me get through this last case,
Mm,
and then we can continue talking about it. I'm
yeah.
not going to go all into it. It's Maria Chavez v. Bondi, again out of the ninth on February 13th, 2025. It's about CIMTs, firearm offenses, stuff. It's about so many things. And I'm not going to get into the majority of it. What I want to talk about is CIMTs and the Loper-Bright decision from the Supreme Court over the summer. And I'm happy and I'm honored that I just spoke at the AILA Georgia Alabama conference on Loper-Bright, and I'll do it again at AILA National. There are other people who could talk about Loper-Bright. I'm happy to do it because I'm a big nerd, and I like to make these conversational too because there are things that I might be missing. But I am reading all the cases, and this one is the most important one that's been issued yet. There's only about 5 in the immigration context. This one, Maria Chavez v. Bondi, the most important, even though it's only one section. And the issue is this. Chevron deference is dead. So for years, the circuits were deferring to the reasonable interpretations of the board on ambiguous phrases, like what is a crime involving moral turpitude, for example, right? Now there's no more Chevron deference. So what do you do to all of these cases, all of this precedent that had relied on Chevron deference, where Chief Justice Roberts is saying that was unconstitutional from the start? There's a throwaway line, in my opinion, from Loper-Bright where the Supreme Court says our prior precedent is subject to stare decisis, so we're not overruling all of our prior precedent just because it relied on Chevron deference. Now, to me, reasonably, that seemed more focused on the Supreme Court's prior precedent, not the circuits, because a fundamental change in law like Loper-Bright, for that to not overturn other stuff, that's wild to me. Like, for example, Dobbs overturns a lot of things at the circuits because it's a fundamental change in law on abortion. And there are other cases like that. Same with Bruin and guns. But the circuits have been using that line to say our prior precedent remains, notwithstanding Loper-Bright. You follow?
Mm-hmm.
But it hasn't really been fleshed out. And here the Ninth Circuit is fleshing it out a lot more. Here the Ninth Circuit said, okay, if we've set a crime as a CIMT in the past, California theft, California fraud, for example, we can't overturn that as one panel just because of Loper-Bright, because of that sentence. But quote, let me get the quote because it's important. I did this before too. I can't get the actual quote, but what they said in Maria Chavez v. Bondi is that the framework that was relied on to get to that's not due stare decisis, because the framework, Chevron, has been overruled. So maybe to get there, to determine that this California fraud crime is a CIMT, they used a certain framework on what is a CIMT and Chevron deference. But now when a similar Arizona fraud crime comes before the Ninth Circuit, they are not bound by that prior Ninth Circuit decision saying that a very similar California one is. And that's an important thing, because to me that gets to the argument I want to be making. If the Ninth Circuit's CIMT definition, for example, is based on Chevron deference, I think we should be attacking that CIMT definition. Or with particular serious crimes, or particular social groups, or so much with employment law. What is a manager for L visas? All these things that are ambiguous. Even if there's a prior decision from the circuit relying on Chevron deference, I think it should be attacked. And here's the Ninth Circuit saying that analytical framework, that might be subject to re-review. Now, with CIMTs, the Ninth Circuit says there's very little daylight between us and the BIA. So, what is a CIMT? We don't really need to relitigate it. But that might not be the case in other contexts. I mean, why is a particular social group made out of immutability, particularity, and social distinction? BIA just made it up. And I'm almost positive that every circuit that's ever reviewed MEVG and WGR, those seminal Ninth Circuit decisions in matter of Acosta, have relied on Chevron deference. They're not doing that on their own. That's pretty wild. And having said all of this, the Ninth Circuit then says this about CIMTs, quote, well, there's 2 types of crimes, says the Ninth Circuit, quote, involving either fraud or base, vile, and depraved conduct that shocks the public conscience. And for the second kind, they quote, will almost always involve an intent to injure, an actual injury, or a protected class of victims, end quote. So, in the Ninth Circuit, two types, says the
Wait, it
Ninth.
said intent under an actual injury because there's like domestic violence. Have said or not violence. Yeah, no, sorry. Go ahead. There's actual injury.
Well, domestic violence might be covered by the protected class of victims, right? A domestic partner or child. But crimes in the Ninth, they either involve fraud or an intent to injure, an actual injury, or a protected class of victims. That's what the Ninth Circuit said. You know what they didn't say? Theft.
Oh,
No theft. And we know that fraud is not theft and theft is not fraud. Matter of Diaz Lizarraga and all of that stuff about how theft crimes can be CIMTs. Here's the Ninth Circuit saying in a quote, two types, didn't mention fraud. Now, don't get me wrong, I don't think the Ninth Circuit was thinking about this. I mean, so two types they didn't mention theft. Now, don't get me wrong, I don't think the Ninth Circuit was thinking about this. That's an excellent quote. And why are theft crimes morally turpitudinous? Board has just been saying it forever, and then they willy-nilly changed the definition of a theft type CIMT in 2016. So these are the kind of arguments that, to me, completely open after Loper Bright, and I will go right into immigration court and say the Ninth Circuit said there's only two types of CIMTs, doesn't include theft, even that this theft crime can't be a CIMT. I'll make that argument all day. Here's the quote from this decision. Maria Chavez v. Bondi, February 13th, 2025. This is what Loper Bright allows us to potentially do.
so federal appeals attorneys, they have fresh meat for a lot of work. I mean, they've been having a lot of work for many years, but it's
Absolutely, but these arguments I think can be making at the immigration court level. I mean, if the board says, and again, don't get me wrong, I'm not sure that the Ninth Circuit maybe knew exactly what they were saying, but maybe they did. Very smart judges with very smart law clerks. If the board says theft crimes are CIMTs, and then the Ninth Circuit flat out says theft crimes are not CIMTs, it's the Ninth Circuit that binds in the Ninth Circuit immigration courts. It's not the BIA. I would use this quote.
yeah.
And Loper Bright is dead. So, you can argue we're at year one. The Ninth Circuit has spoken. Immigration judge, this theft crime is not a CIMT. Also, immigration judges don't like to be overturned, at least the ones who want to be judges.
Yeah.
And so to make a complex argument and to have the judge know that, they can't rely necessarily on the circuit now deferring to the BIA, maybe that pushes the immigration judge to make a decision for a different reason. And maybe that decision is weaker. We can still be making Loper Bright type arguments at the immigration judge level, even if they don't technically bind.
Have there been any other Lofer Bright, Chevron deference going away cases in the immigration space yet? Because it's been a year now since it happened.
No, it's been like 7 months. July.
Had there been groundbreaking stuff happening yet? I thought dominoes would be falling and end the world, but it's like, oh, nothing changed.
Right. Right. No, before this case, the most important one was also out of the Ninth Circuit. I think the Lopez decision, but honestly, this one's more important. And three other circuits have mentioned it, but they haven't really said much. It hasn't had much effect in immigration yet. I don't even think it's had that much effect anywhere else
Yeah.
yet. It's been applied, and the judge used it too in the parole case. The district court judge used it, finding Biden's parole program or his parole in place program unconstitutional, in violation. But so it's been used, but I don't even think it's been overly used yet in the non-immigration agency context. But of course, it's coming.
I mean, I would imagine like the oil companies would be suing the EPA over it, like nonstop. Like I mean, they might be going up the chain with those lawsuits or something. But I thought it would have been a really big deal, groundbreaking.
Why sue the EPA if the EPA won't exist in a month?
That might be it. It's like save the money.
Right.
So there's this case that brought up CBP's policy now, where if you have an I-751 denied, you're in immigration court, and you travel with the green card, which is still a valid green card, they're not going to let you return in. Have you heard about that fact, that pattern that came out of Logan, Boston Airport?
That what? I'm sorry. No, but I have not heard it.
So from what we gather is and I think Ayla sent a breakdown of the policy, but CBP is new, like public policy is that if you have a removal of conditions case that's denied by USCIS and the case is in before IJ and you travel with the green card, that's still, you get the extension if you file it. Then they won't let you back in. They'll say you don't have a green card or something like that. Hopefully, I'm not
There's a
butchering the
lot.
facts.
I haven't heard that. There's a lot wrong with that. First of all, it's pretty black letter that conditional LPRs have all the same rights and privileges as regular LPRs. There's also BIA precedent that pretty much says you have to give CLPRs their day in court to get de novo review of their
Yeah.
LPR status. So if what CBP is saying, we're going to treat these people as arriving alien applicants for admission just because they had their CLPR status terminated and they're in immigration court, I'm not sure what ground of 118.13c that would even fall under. Certainly wouldn't be abandoned. But no, actually, well, there is a well, there is a 101.813c, right? If you're in the process of legal proceedings to determine your removability, that is a 101.813c provision. Maybe that's it, because even fraud is not, in my opinion, even if you have a denial of your I-751 based on fraud, even that's not a reason to deny to treat someone as an applicant for admission returning green card holder, but
So
that's
the
debatable.
travel advisor is like, okay, they're saying they don't have a case with USCIS pending, and so it's terminated because they did this thing where if your I-751 stage you get terminated, you could get married with someone new, and on its face of it, like you're not a resident, so you get a new one. You don't need to do a I-407, N-407, or whatever I-407. But here, the person had an I-551 stamp, and left while the case was in court. Now I imagine, like, I never had I-751 denied, but the second I would have it denied, I would immediately refile USCIS to keep jurisdiction with USCIS. I think it remains with USCIS if we file with them. That would be the tactic, and not even let it get to court. Like try to close the terminate the case because USCIS jurisdiction.
Well, you can have a 751 pending with USCIS while you're in removal proceedings, and matter of Stowers says that the immigration judge, I think it's Stowers, says they need to continue proceedings for the new 751 to resolve itself. The second they terminate it, you should be placed in immigration court proceedings for de novo review of that. I mean, it can be a good thing. You might get a better
Yeah.
shot,
So
but
yeah.
I don't think that's right. They have all of the regular. They are even though USCIS has their policy, which is a benefit to CLPRs, like you said, because they can remarry. It remains the case that a CLPR is a CLPR until an immigration
Yeah.
judge says they're not. I don't even plead to the charge of removability in immigration court for that reason. I'll say something like, Judge, I'm not contesting that USCIS terminated their conditional status, but this person is not, their conditional status is not terminated until you say so. So I'll deny that removability charge every time.
So yeah, 'cause I got an email
Uh,
saying Supervisor at Logan has confirmed that is their policy, that they're inadmissible. So I'm like, that's
they can have whatever policy they want, but inadmissibility is different. You have to have a reason for inadmissibility, and
not having a
they are
valid. They do that, not having a valid travel document that
that's
HL
not
212, whatever thing they always say.
that's not right. But where are you going to challenge that? I mean, you got to go to federal court. That's a nightmare. So
Yeah.
maybe I'm not saying that best practice isn't to travel. I'm just saying that's not right.
Yeah, I mean, I would just if I was in removal proceedings, I definitely wouldn't travel. But I guess sometimes you got to travel, might be emergencies. But that was like the big one, and that sent shockwaves because understanding the complexity we just discussed, once it goes on TikTok, becomes a mess of they're not letting green card holders back into the country, and then that's like the fire that you get 1,000. You probably got it. Everyone got it to listen to this. Tons of calls. I'm a green card holder. Can I travel? I know this is like very specific fact pattern.
I'm not gonna lie. I don't. I have very little sympathy for the people going to immigration judges based on immigration attorneys based on the things they see on TikTok.
No, it just creates a lot
Um,
of work for us. The answer, like, no, don't listen to them.
I
Like clients, like
yeah,
they're
no.
on fire. Yeah,
Well, I mean, they got to pay our consultation fees, and we don't get a lot of people who see something on TikTok and then want to pay our consultation fees to be told that what you saw on TikTok is possibly crazy. So maybe that does protect us a little bit, but these are very scary times,
yeah.
and you should speak with an attorney and not believe everything you see on TikTok. All of that is to say that's probably happening in Boston. I don't know. Like I can't tell someone to travel.
Mm.
I wouldn't tell someone to travel who's in removal proceedings with
Yeah.
an I-751. I'd say that these are your rights, but like,
It's
I might be right,
discretionary. I
but
mean, who
that
knows what these people
officer,
do? Yeah, they can make things up for. I mean, last travel ban that Trump did, they weren't letting U.S.-born Iranians re-enter the U.S. in the Northwest some border pass, and eventually they got sued. And they apologized and said it was a rogue agency. Who knows? But like, you never
right.
know. Yeah, they do whatever they want to do. Then it's like one of those things: shoot them all, let God sort them out. Kind of. It's like whatever. They just get a slap on the
That's
wrist.
I mean they're clearly doing that in many contexts right now, so that it's very hard to advise because it is act now, think later,
Yeah, I had the
rectify
colleague.
it later if we
He
have
had
to.
a SILE who had his USCIS asylum interview, and then they're waiting on a decision 3 weeks, and then all of a sudden ICE comes and detains him, takes him to whatever detain. I don't want to take too much details because I don't know how public it is, but Southern California Detention Center. And he called him up. He's like, "Dude, this guy's asylum came pending 7 years, and like we're waiting on a decision." Like as you know, the new memo, they don't defer to U visas, VAWA, or asylum anymore to pick people up. And it seems like they have numbers, they have to quota numbers they have to reach allegedly. So it's kind of like at first it's like, okay, pick up the criminals, but it's like, do you really want to go pick up a criminal that might have a gun, or just pick up a poor person that just sitting at home is not going to be fighting back? Which was easier to reach the quota on? So that's what happens.
No, it's crazy what we're seeing. They definitely have they absolutely have quotas. I feel for these ICE officers. I mean, they've got quotas. Their jobs are on the line. It's this so quickly in America. So quickly,
Yeah.
we so much of America has turned into the complete criminalization of immigrants. It's a scary thing, and I will not stand for it. So I'm doing everything I can, whether it's on one small individual case or on impact litigation, to try to retake the narrative.
Mm-hmm. Well, brother, thank you so much for coming on. We're gonna have another wild 4 years together, so let's do it. It's a lot to talk about, but I appreciate you coming on. Kevin Gregg, host of the Immigration Review podcast, top podcast in the podcasting game. K Gregg with two G's at kktplaw.com. Definitely, I recommend complex case. Send him. Whenever someone calls me with some complex stuff, I'm just like, just stop. Go, Kevin. Like you're not. That's too complex for me. Go to Kevin, and he'll help you out. So appreciate you coming on the show and spending all time with us.
It's very kind of you to say, John. Thank you so much, and I appreciate everything you do as well.
Thank you.
Have a great night. See you in a month.
See you in a month. Thank you so much for listening. Kevin is always a great person to interview and talk about. It's so nice that he's on our show. If you haven't already, catch his podcast, Immigration Review Podcast, found wherever podcasts can be found. As a reminder, our E2 seminar is coming March 20th. Probably going to start doing like the third Thursday of every month, 10 a.m. Pacific time, 1 p.m. Eastern. It's not recorded. It's live only. Each time is kind of different than when we do it. And we have different questions and stuff. I'm just keep fine tuning, make a better course out of it. But it's very lively, interesting, fun. And it's, again, we have a lot of repeats, so it shows that people like it. So if you want more information about that, email me at info@immigrationlawyerstoolbox.com. Side note, I keep forgetting to mention this, but we get a lot of new students. We have a course called the Ultimate Marriage Green Card course that goes over marriage green card, how I run my practice, and everything associated with doing that kind of thing. And the success I've had, I just kind of documented it, have like hours and hours of videos and live sessions and one-on-ones. It's really good. Again, we have recently this year got a lot of new students. I just keep forgetting to talk about it, but it's the main thing that we have. If you're interested in that, send in an email where, again, it's info@immigrationlawyerstoolbox.com. I wish you all the best. Bye-bye.